Good afternoon. Happy Sunday. A attorney out of Texas sent this to me. This is C.J. Grisham, appellant versus the state of Texas, appellee. I have not read this decision. This is an appeal that C.J. did off of the arrest where he was walking down the road with a firearm strapped to him. I think he was arrested back in like 2013 or 2014. I don't remember exactly. It was a long time ago. I remember, maybe it was later than that. I remember covering it ever so quickly. I thought I covered it. Anyway, if I didn't cover it, then my bad. I want to say on the record that I support gun rights and I support open carry, and I appreciate what CJ has done for gun rights in Texas, assuming that what he claims to have done for gun rights is actually related in part to his work to secure those rights. So I'll take him at his word for that. I do like gun rights. Now, I am told that this opinion makes him look like a bit of a twat, and so I'm kind of interested to read it because I haven't seen any of these lawsuits against the judge that CJ promised after him making videos calling me out for my misunderstanding of the law, but then deleting or privating the videos he made about me, where he called me out, where he explained his habeas pistolis or his 1983 lawsuit theories against the judge. So, anyway, apparently I just have a bone to pick with him. I can't just dislike people who say stupid shit about the law on the internet and work to debunk them. But anyway, this was sent to me by an attorney. I haven't read it, so I hope it's good. I hope it's interesting. It is long. It is like 9.5 pages long, so we're going to go through it. We'll get through it. This is from the Texas Court of Appeals, 3rd District at Austin. This is not for publication, is my understanding. So we'll go ahead and go through it, and we'll see what the court has to say. So this is a memorandum opinion. A jury convicted appellant Christopher Grisham of the misdemeanor offense of interference with public duties and assessed a $2,000 fine as to his judgment, or as to his punishment. See Texas Penal Code sections 3815A1, providing that a person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. And it also references section 12.22, setting forth punishment range for Class B misdemeanors. Now, as I understand Texas Class B misdemeanors, the maximum fine is $2,000. So he did receive the maximum fine, but he could also get 180 days in jail. He did not get, to my knowledge, any time in jail other than time served on the initial, when he was arrested, before he was bonded out. So he was not sentenced to any time in jail, and he got the maximum monetary fine. On appeal, appellant challenges the denial of his motion to suppress evidence and asserts that the trial court erred by denying his requested defensive jury charge instructions. We affirm the trial court's judgment of conviction. So my understanding is that he is pro per when he did his appeal, but I believe that he was represented at trial. I believe he had an attorney at trial, but he is pro per on the appeal. So we have the background. Because the parties are familiar with the facts of the case, its procedural history, and the evidence adduced at trial, adduced means admitted into evidence at trial, we provide only a general overview of the facts of the case here. We provide additional facts in the opinion as necessary to advise the parties of the court's decision and the basic reasons for it. The facts recited are taken from the testimony and other evidence presented at trial. Steve Ermis, a police officer with the Temple Police Department, was dispatched in response to a 911 call reporting an armed man walking down the roadway. Officer Ermis responded to the location reported and found appellant and his son walking nearby. They were walking in the roadway on the wrong side of the road, that is, on the right-hand side, traveling in the direction of traffic with their backs to oncoming cars. The officer observed that appellant was carrying a rifle in an offensive combat-ready position across his chest, immediately accessible and ready to be fired as opposed to slung across his back. Officer Ermis pulled up behind appellant and his son to initiate contact. As he exited his patrol car and approached, he instructed appellant not to touch the weapon. The officer began questioning appellant about his activities and his reason for having the weapon. Officer Ermis examined the gun and determined it was a real weapon and that it was loaded. He moved to disarm appellant by releasing the clasp holding the firearm to the shoulder strap of appellant's backpack. As he did so, appellant grabbed the weapon. Never grab the weapon. Never, if you're in a situation like this where you've been detained by the police, never grab your weapon. That's a quick and easy way to get shot. I'm not saying that they should be able to shoot you, but they are able to shoot you. So don't grab your weapon. Let him disarm you. Fight it out in court. And told the officer not to disarm him. Unsure of appellant's intentions and fearful for his safety, always officer fear for safety, Officer Ermis drew his service weapon and ordered appellant not to touch the weapon. He placed appellant against the hood of his patrol car and attempted to place appellant's hands behind his back to handcuff him. Appellant allegedly refused to comply with the officer's instructions and forcibly resisted the officer's efforts to handcuff him. So it sounds like that is meeting the interrupts, disrupts, impedes, or otherwise interferes with the peace officer. Essentially, it's resisting arrest. Eventually, appellant was handcuffed and arrested for resisting arrest. Oh, there you go. All right. So appellant was subsequently charged by information with the misdemeanor offense. Charged by information is different than a charge by grand jury. It just means basically that that the officer's report is turned into an affidavit. It's given to like a magistrate, if I understand Texas correctly, and the magistrate basically okays a information. It's like a civil complaint. Like when you write up the civil complaint, it basically lays out the charges against the defendant. So appellant was subsequently charged by information, and that's opposed to a grand jury where the prosecutor will go in, will present all of the evidence that supports the state's position to the grand jury, and the grand jury will return a true bill saying that yes, the person most likely has committed the offense, and go ahead and charge and arrest and all that other fun stuff. Appellant was subsequently charged by information with the misdemeanor offense of interference with public duties. Prior to trial, appellant moved to suppress, in quotes, the arrest, end quote, and any they're making a big deal out of that already. So prior to trial, appellant moved to suppress the arrest and any statements he made during the encounter. I see. Reasonable suspicion. I get it. Okay. After conducting a hearing, the trial court denied the motion to suppress, and the case proceeded to a jury trial. The jury found appellant guilty of interference with public duties as charged and assessed a $2,000 fine as punishment. This appeal followed. So the discussion of the denial of a motion to suppress. Prior to trial, appellant filed a motion to suppress. Did he or did his attorney? I thought he had an attorney at trial. I could be wrong. In his written motion to suppress, appellant asserted that he was unlawfully arrested without probable cause. He referenced the 4th, 5th, 6th, and 14th Amendments to the United States Constitution. So I get the 4th. I don't get the 5th. I don't get the 6th. The 4th applies through the 14th, so maybe? I don't know. Anyway, he referenced the 4th, 5th, 6th, and 14th Amendments. Why not just say the whole damn thing, the whole shebang, to the United States Constitution? Article 1, Section 9, 10, and 19 of the Texas Constitution, and Articles 38.22 and 38.23 of the Texas Code of Criminal Procedures. No arguments were presented in the written motion regarding a violation of his constitutional or statutory rights based on the absence of reasonable suspicion for his detention. There you go. There's your reasonable suspicion. So that's why the court was highlighting the arrest. Okay. So a cop can probably disarm you in a Terry stop. And if you refuse to be disarmed in the Terry stop, that could be interfering with the public duties of a peace officer. A hearing was held on the motion. Officer Ermis testified, and the exhibits included the patrol dash cam video recording depicting the encounter. So the hearing, it was an evidentiary hearing. They had the officer testifying at the evidentiary hearing, and they played the patrol dash cam video. Appellant's questioning of the officer focused primarily on whether the officer had probable cause to arrest him without a warrant, not whether the officer had reasonable suspicion to detain him. I can smell where this is going. At the conclusion of the hearing, appellant maintained the officer lacked probable cause to arrest him. However, in response to the state's questioning of the officer, appellant also referenced the absence of reasonable suspicion to detain him. Interesting. So in his redirect or in his cross, he did bring up reasonable suspicion. The trial court took the case under advisement, but he did not present it in his motion. I think that's where we're going on this. So he did touch upon it in his cross-examination or in his redirect. I don't know who led off with the questioning of Officer Ermis, but he did not include that in his motion. The trial court took the case under advisement. Subsequently, the trial court denied the motion to suppress without making any findings of fact or conclusions of law. I want to point out at this point, I may be overly critical of anything that CJ has done in here, because CJ he's now graduated from law school. He has passed the bar exam, but he is not necessarily, well, he may have at this point, I don't know for sure. He may or may not have actually passed the bar. He may actually be a member of the Texas State Bar. So I have to remember, and I hope you remember too, to judge him at this point as a layman, because he was not even a law school student at the time that he did this appeal. So just bear that in mind. We need to cut him a bit of slack. But there we go. The trial court took the case under advisement. Taking the case under advisement means that the trial court didn't render a ruling right then and there, but took some time to think about it, to maybe do some independent legal research on it, and then to usually it's to write. I see that the court denied the motion without making any findings of fact or conclusions of law. Normally, when a court takes it under advisement, in my experience, they come back with a written statement of decision saying, like, what they found as a matter of fact, what their conclusions are as a matter of law, and that helps if you are going to appeal. It helps to have that written statement of decision. So I'm surprised that the court took it under advisement without coming back with a written statement of decision, but I guess the court did it this time. So the court denied the motion to suppress without making any findings of fact or conclusions of law. In his first point of error, appellant contends that the trial court erred in denying his motion to suppress because the officer lacked probable cause to arrest him or reasonable suspicion to detain him. So now he's adding on the reasonable suspicion in his appeal. What do we got here? To preserve a complaint for appellate review, a party must present a timely request, objection, or motion to the trial court stating specific grounds for the trial or for the desired ruling. So yeah, that's going to bite him in the ass. In addition, the issue raised on appeal must comport with the objection made at trial, i.e. an objection stating one legal basis may not be used to support a different legal theory on appeal. A motion to suppress evidence is a specialized objection to the admissibility of evidence. Thus, appellate contentions regarding suppression must comport with the specific assertions made in a motion to suppress, and an appellant fails to preserve error when he files a motion to suppress, when he files, not argues, a motion to suppress arguing one legal theory at trial and then asserts a different legal theory on appeal. Arguably, because the basis for suppression urged in appellant's motion to suppress was an unlawful arrest without probable cause, his complaint about the illegality of his detention was not properly preserved for appellate review. However, in the interest of justice, we'll address the merits of appellant's contention that Officer Ermis lacked reasonable suspicion to detain him. So that's a giant fuck you. Not only did you fuck up with preserving your appeal, preserving your motion for appeal, but you also still fail. We review a trial court's ruling to suppress evidence for an abuse of discretion. Abuse of discretion, there's two ways that a court of appeals can generally do a review. There's de novo, where they assess the facts and they make a determination about the law. Or there's abuse of discretion, where they just assume all the factual things that the lower court decided. They construe any questionable facts as though those facts support the trial court's decision, and they're really looking to see if the court came to some absurd decision or showed bias in their decision. Like if CJ wanted to bring a witness to testify that CJ was walking on the correct side of the road, not the wrong side of the road, and the court denied it, just flat out denied it because the court didn't like CJ, that would be an abuse of discretion. So it's the court's really looking, the appellate court is really looking for something kind of in your face. It's a very hard bar to hurdle. It's most often the Court of Appeals is going to find that the trial court did not abuse their discretion. That's just, yeah. Oh, here we go. And overturn the ruling only if it is outside of the zone of reasonable disagreement. So they're looking for an absurd result. We apply a bifurcated standard of review, giving almost, I got too hasty explaining it, giving almost total deference to a trial court's findings of historical fact and credibility determinations that are supported by the records, but review questions of law de novo. We view the evidence in the light most favorable to the trial court's ruling and uphold the ruling if it is correct on any theory of law applicable in the case, even if the trial judge made the ruling for the wrong reason. In our review, the prevailing party is afforded the strongest legitimate view of the evidence and all reasonable inferences that may be drawn from it. Reasonable suspicion that a person may be involved in criminal activity permits an officer to stop and briefly detain the person to take additional steps to investigate further. A police officer has reasonable suspicion for a detention if he has specific, articulable facts that, when combined with rational inferences from those facts, would lead him to reasonably conclude that the person detained is, or has been, or soon will be engaged in criminal activities. The likelihood of criminal activity need not rise to the level required for probable cause. The reasonable suspicion standard requires only some minimal level of objective justification for the stop. A reasonable suspicion determination requires consideration of the totality of the circumstance. The test for reasonable suspicion is an objective standard that disregards the subjective intent of the arresting officer and focuses instead on whether there was an objectively justifiable basis for the detention. It is enough to satisfy the lesser standard of reasonable suspicion that the information is sufficiently detailed and reliable, i.e., it supports more than an inarticulate hunch or intuition, to suggest that something of an apparently criminal nature is brewing. Whether the facts known to the officer amount to reasonable suspicion is a mixed question of law and fact subject to de novo review, noting the historical fact findings subject to abuse of discretion review, whereas ultimate legal rulings such as probable cause subject to de novo review. So the court is going to be able to look at the facts. I think we have a bit of a head start as to where the court is going, because in the initial statement of facts, the court said that Grisham was walking in the roadway going the wrong direction. He was on the right-hand side of the road with his back to traffic, i.e. he was violating some sort of a traffic law. Ergo, at least reasonable suspicion to detain. I would actually guess we're going to hear probable cause. Evidence at the suppression hearing showed the police received a call from a woman who reported seeing an individual walking down the roadway armed with a big black gun. Well, that's just racist. Why do you have to bring the race of the gun into the whole argument here? Why has it got to be a black gun? Why can't it be an African-American gun? That's a joke, folks. It's a joke. The responding officer, Officer Ermis, testified that he was dispatched in response to the call and found appellant and his son walking near the location reported by the caller. When he encountered them, the officer observed that they were walking in the roadway on the wrong side of the road, on the right-hand side, traveling in the direction of traffic with their backs to the cars. There we go. At the hearing, the officer testified he knew this conduct to be a violation of the Transportation Code. See Texas Transportation Code, Section 552.006b, specifying that if a sidewalk is not provided, pedestrian must walk on the left side of the roadway or on a shoulder of roadway facing oncoming traffic. Officer Ermis's testimony demonstrated that he had specific, articulable facts establishing the appellant had committed a pedestrian traffic offense. Citing this case where testimony established the officer had belief based on specific facts that appellant had committed a pedestrian traffic offense. And another one that says if an officer has a reasonable basis for suspecting that a person has committed a traffic offense, the officer may legally initiate a traffic stop. Thus, the trial court had before it evidence of an objectively justifiable basis for the detention. Appellant complains in his brief, as he did at the suppression hearing, that Officer Ermis did not articulate prior to the hearing in his offense report or other documentation concerning the offense that the Transportation Code violation was a basis for appellant's determination. I hear this so many times when auditors are out there and they're like, specify your articulable, reasonable, probable suspicion cause. And the officer sometimes will say no and just handcuff them and whatever. And I've said time and again, the cops don't have to explain it to you. They have to explain it to the court. Once they get to court, in this case, it was at a suppression hearing, but it might make it all the way to trial. But it's at court that the officer has to articulate his reasonable suspicion or the facts that underlie his determination of probable cause. However, what Officer Ermis documented or relied on at the time of detention is irrelevant. The standard for reasonable suspicion is objective, not subjective. Thus, there need only be an objective basis for the stop. The subjective intent of the officer is irrelevant. This is an objective standard that disregards the actual subjective intent of the arresting officer and looks instead to whether there was an objectively justifiable basis for the detention. We conclude that the record supports the trial court's implied finding that, based on the totality of the circumstances, Officer Ermis had reasonable suspicion for the detention of the appellant. In their briefing, the parties dispute whether, under the circumstances of this case, Officer Ermis had reasonable suspicion to detain appellant based on his carrying a rifle as he walked down the roadway. Appellant maintains that he was not subject to detention because, as appellant correctly notes, openly carrying a long gun in public generally is not illegal in Texas. Citing the Texas Constitution that says every citizen shall have the right to keep and bear arms in the lawful defense of himself or the state. The state maintains that Officer Ermis had reasonable suspicion to detain appellant because he believed appellant was committing or had committed the offense of disorderly conduct. That's Texas Penal Code Section 42.01A8. A person commits an offense if he intentionally or knowingly displays a firearm or other deadly weapon in a public place in a manner calculated to alarm. I don't like the state's argument there. See also Texas Constitution Article 1, Section 23, that the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime. And citing Ex parte Po, although there clearly are constitutional rights to bear arms and to express oneself freely, there is no constitutional protected right to display a firearm in a public place in a manner that is calculated to alarm. See, I don't think he was just carrying the firearm the way he was doing it. I don't think is calculated to alarm. I think like if you pointed at somebody, or if he had his hand like on the grip with his finger by the trigger, that might be. But I don't think just carrying it would meet the standard there. The issue, however, is whether the trial court could conclude, based on the totality of the circumstance, that Officer Ermis had reasonable suspicion to detain appellant. Given that the undisputed evidence demonstrating the appellant was committing the pedestrian traffic offense when Officer Ermis encountered him, the trial court's conclusion that the officer had reasonable suspicion to detain appellant is supported by the record. A possible alternative basis for reasonable suspicion, or lack thereof, is not dispositive in this case. If the trial court's ruling regarding a motion to suppress is reasonably supported by the record and is correct under any theory of law applicable to the case, the reviewing court must affirm. And that was 3. When the trial court does not file findings of fact concerning its ruling on a motion to suppress, we assume the trial court made implicit findings that support its ruling, provided that those implied findings are supported by the record. After Officer Ermis pulled up behind appellant and his son, he exited his patrol car and approached appellant, instructing him not to touch the weapon. When the officer made contact, he asked appellant what he was doing. Appellant responded, "We're hiking." The officer then asked appellant why he had the weapon. Appellant responded, "Because I can." As he questioned appellant, Officer Ermis examined the rifle to determine if the weapon was a real firearm or a toy gun. He determined the rifle was not a toy but an AR-15 style rifle, and further that it was loaded. The officer observed that a magazine was inserted into the firearm, and the magazine had a clear window that allowed him to see that the magazine had live rounds inside. Uncertain about appellant's intentions relating to the loaded weapon immediately at his disposal, which made the officer feel threatened, officer safety, Officer Ermis sought to disarm appellant so he could safely conduct his investigation. If an officer is justified in believing that a person whose suspicious behavior he is investigating is armed, he may frisk that person to determine if the suspect is in fact carrying a weapon, and if so, to neutralize the threat of physical harm. The purpose of a Terry frisk is not to discover evidence of a crime, but to allow the officer to pursue his investigation without fear of violence. Appellant conceded at the suppression hearing that Officer Ermis had the authority to disarm him. Because he did. To disarm appellant, Officer Ermis reached up to release the clasp holding the weapon to the shoulder strap of appellant's backpack. At that point, appellant grabbed the weapon and loudly told the officer not to disarm him. Again, concerned for his safety and not knowing appellant's intentions, Officer Ermis drew his service weapon and ordered appellant to take his hands off the gun. He placed appellant on the hood of his patrol car, repeated his instruction for appellant to keep his hands away from the gun. Officer Ermis then holstered his weapon and asked appellant to put his hands behind his back. Appellant refused. The officer repeated the instructions several times, but appellant continued to refuse to comply. Appellant then physically resisted the officer's efforts to put appellant's hands behind his back to handcuff him. Eventually, the officer was able to handcuff appellant. After Officer Ermis made several attempts to physically place appellant's hands behind his back, appellant agreed to comply if the officer allowed him to give his camera to his son so that his son could record the encounter. Appellant ceased his struggles against the officer after his son retrieved the camera. You know, that's a great father-son teaching moment there, CJ. Good job, buddy. Appellant was subsequently arrested for resisting arrest. A police officer may arrest an individual without a warrant if there's probable cause to believe an offense has been or is being committed with respect to that individual, and the arrest falls within one of the statutory exceptions to the warrant requirement set out in the Texas Code of Criminal Procedure. See the Texas Code, yada yada, listing situations under which police officer may arrest a person without an arrest warrant. One such exception is if the offense is committed in the presence of or within the view of a peace officer. See Texas Code of Criminal Procedure. A peace officer may arrest an offender without a warrant for any offense committed in his presence or within his view. See also this case that says a warrantless arrest for offense committed in the officer's presence is reasonable if the officer has probable cause. Probable cause for a warrantless arrest exists if, at the moment the arrest is made, the facts and circumstances within the arresting officer's knowledge and of which he has reasonably trustworthy information are sufficient to warrant a prudent man in believing that the person arrested had committed or was committing an offense. The test for probable cause is objective. It is unrelated to the subjective beliefs of the arresting officer, and it requires a consideration of the totality of the circumstances facing the arresting officer. The ultimate question here is whether, at the moment of appellant's arrest, facts and circumstances within Officer Ermis's knowledge, or of which he had reasonably trustworthy information, were sufficient to warrant a prudent person in believing that appellant had committed or was committing a criminal offense. Officer Ermis's testimony at the suppression hearing established that during his encounter with appellant, number 1, appellant grabbed his weapon and tried to keep the officer from disarming him. 2, appellant did not put his hands behind his back when asked and refused to comply with that instruction at least 6 times. And 3, appellant physically resisted when the officer tried to grab appellant's hands to place them behind his back to handcuff him. These facts were sufficient to permit a prudent person to believe that appellant had committed the offense of resisting arrest or search. See Texas Penal Code 38.03. A person commits an offense if he intentionally prevents or instructs a person he knows is a peace officer from effecting an arrest or search by using force against the peace officer, concluding that pulling away from officers satisfies the use of force against peace officer requirement of resisting arrest. Accordingly, we conclude that the record supports the trial court's implied finding that based on the totality of the circumstances, Officer Ermis had probable cause to arrest appellant without a warrant for an offense committed within his presence. In sum, viewing the evidence in the light most favorable to the trial court's ruling, the record demonstrates that not only did Officer Ermis have reasonable suspicion to detain and arrest appellant initially based on the pedestrian traffic violation, but as the situation evolved, he developed an additional basis, supported by probable cause, to arrest appellant without a warrant for resisting arrest offense committed in his presence. Accordingly, we conclude that the trial court did not abuse its discretion by denying appellant's motion to suppress. We overrule appellant's first point of error. The next is denial of the requested jury charge instructions. In his next 2 points of error, appellant contends that the trial court erred by denying his request for 2 defensive instructions in the jury charge: an instruction on the statutory speech-only defense and an instruction on self-defense. We review alleged jury charge error in 2 steps. First, we determine whether error exists. If so, we evaluate whether sufficient harm resulted from the error to require reversal. The trial court... There is a woodpecker on that tree right out there. Right out there. Do you see it on the tree?
Yes.
Go get it, Annie Oakley. All right. The trial court must provide a jury with a written charge distinctly setting forth the law applicable to the case. If you want the shotgun, it's right there, next to the jacket. Next to the jacket. Hell yeah, brother. Go get him. In fulfilling the duty, the trial court is required to instruct the jury on statutory defenses, affirmative defenses, and justifications whenever they are raised by the evidence and requested by the defendant. A defensive issue is raised by the evidence if there is some evidence, regardless of its source, on each element of a defense that, if believed by the jury, would support a rational inference that the element is true. When deciding whether a defensive issue has been raised by the evidence, a court must rely on its own judgment, formed in light of its own common sense and experience, as to the limits of rational inference from the facts that have been proven. A defendant is entitled to an instruction on every defensive issue raised by the evidence, regardless of whether the evidence is strong, feeble, unimpeachable, or contradicted, and even when the trial court thinks that testimony is not worthy of belief. So, if you've adduced any evidence, good, bad, or otherwise, that supports a jury instruction, the trial court has to allow that jury instruction. A judge must give requested information or requested instruction on every defensive issue raised by the evidence without regard to its source or strength, even if the evidence is contradicted or is not credible. When reviewing a trial court's ruling denying a requested defensive instruction, we review the evidence in light most favorable to the defendant's requested instruction. The question of whether a defense is raised by the evidence is a sufficiency question, which we review as a question of law. Statutory defense. A person commits the offense of interference with public duties if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. It is a defense to prosecution if the interruption, disruption, impediment, or interference consisted of speech only. Speech only. We've just established they pulled away, but we're going to hear about speech-only defense. At trial, appellant requested a jury charge instruction on the statutory speech-only defense, which the trial court denied. In his second point of error, appellant contends that the trial court erred in failing to include the statutory defense instruction in the jury charge. Appellant's belief fails to include any analysis, argument, or citation to the record to support his contention that the trial court erred in failing to include the requested instruction on the statutory defense. Beyond proffering a few statements of law, the statutory defense as set forth in the Penal Code, and an excerpt from one opinion to this court, appellant makes no effort to analyze how the case or how the law applies to the circumstances in this case. He does not identify the comments or statements upon which he founds his speech-only defense. Similarly missing is any discussion about how the evidence raised at trial supports his request for the statutory defense. Nor does appellant specify any portion of the record that demonstrates his efforts to show the trial court why he was entitled to this defensive instruction. Instead, appellant merely summarily asserts that the trial court erred in failing to submit the statutory defense on the court's charge to the jury. Such conclusion is not enough to comply with the briefing requirements of Rule 38.1I of the Texas Rules of Appellate Procedure, or to preserve the complaint for appellate review. An appellant has the obligation to provide a clear and concise argument for the contentions made with the appropriate citations to authorities and to the record. Encompassed within that duty is the task of explaining or discussing why his argument has substance. Appellant's failure to adequately brief this issue by failing to specifically argue and analyze his positions or provide record citations presents nothing for our review. Appellant's brief contained no argument or citation to any authority that might support argument. Therefore, court decided point of error was inadequately briefed and presented nothing for review, as this court is under no obligation to make appellant's arguments for her. And then this one, affirming that appellate court has no obligation to construct and compose parties' issues, facts, and arguments with appropriate citations to authorities and to the record. In this case, where appellant failed to proffer any argument or authority with respect to claims and therefore waived any error as to claims due to an inadequate briefing. We overrule appellant's second point of error due to inadequate briefing. So that's interesting. The court kind of gave him a pass on the first one that said, basically, you screwed up, but even if you hadn't screwed up, you still would have lost. This one, they just said you screwed up. They didn't bother to delve into it any deeper. Now, self-defense instruction. I have made multiple videos that bad elk is bad law. You, generally speaking, don't have a common law right to self-defense. Now, against an arrest by a police officer. Now, check with a local attorney. Your state might have an exception to that, where your state might statutorily allow you to resist an unlawful arrest even by a police officer. But that is the exception, not the rule. So check with a local attorney. And I still wouldn't recommend that you resist arrest, even what you believe is an unlawful arrest, because if you end up dead, there's no way to appeal your death. You know what I'm saying? All right, so the self-defense instruction. Section 9.31a of the Penal Code establishes the elements of a self-defense and provides in relevant part that a person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. That's what's going to bite. That's what's going to bite him in the ass. I could already see it here. Subsection B of the statute then establishes certain exceptions to the self-defense, including that the use of force against another is not justified to resist arrest. To resist arrest or search that the actor knows is being made by a peace officer, even though the arrest or search is unlawful, unless the resistance is justified under subsection C. So it's not allowed unless it's under subsection C. Subsection C provides the use of force to resist an arrest or search is justified if, Before the actor offers any resistance, the peace officer uses or attempts to use greater force than necessary to make the arrest or search, and to when and to the degree the actor believes the force is immediately necessary to protect himself against the peace officer's use or attempted use of greater force than necessary. So it's joined by an and, so you need both of these to be true. So the police officer has to use greater force than necessary to make the arrest or search, and you can only use self-defense to the degree that you reasonably believe is necessary to protect yourself against that use of greater force than necessary. In his third point of error, appellant asserts that the trial court erred by denying his requested jury charge instruction on self-defense. Specifically, he argues that the trial court erred in not submitting an instruction that self-defense is a defense to resisting arrest. He asserts that the evidence that Officer Ermis arrested him for resisting arrest was sufficient to require the trial court to submit the self-defense instruction to the jury charge. We disagree. First, the right to use force against a police officer who's attempting to effectuate an arrest or search is limited. Under Section 9.31c, a defendant must show greater force than necessary on the part of the police officer before the justification of self-defense is applicable. Thus, to be entitled to an instruction pursuant to Section 9.31c, there must be some evidence in the record to raise the issue of whether the peace officer used or attempted to use greater force than necessary in attempting to arrest or search the defendant. Appellant fails to identify any such evidence in his brief. At trial, to support his claim that Officer Ermis used excessive force against him, appellant relied on Officer Ermis's responses during cross-examination, indicating that he could have asked appellant to relinquish his weapon, but instead chose to physically disarm him. This testimony, however, does not demonstrate that the officer used, in quotes, excessive force, end quote, or, in quotes, greater force than necessary, end quotes, to disarm appellant. Only the appellant disagreed with the method used to disarm him because the officer did not use appellant's preferred method, a verbal request that he considered, in quotes, less intrusive, end quote, or, quote, less invasive, end quote, than physically taking the weapon. Appellant provided no authority to the trial court establishing a requirement that a police officer must first ask an armed suspect to give up his weapon before physically disarming him. Indeed, announcing an intent to disarm a subject could, in some instances, pose a safety risk to the officer. Furthermore, in order for a trial court to submit a self-defense instruction to the jury, a defendant must produce sufficient evidence on each element of the defense to raise the issue. A defendant bears the burden of production in a self-defense claim, which requires the production of some evidence that supports the particular defense. See also Texas Penal Code 2.03c. The issue of the existence of a defense is not submitted to a jury unless evidence is admitted supporting the defense. The defendant bears the burden of showing that each element of the defense has been satisfied. In this case, even assuming Officer Ermis used excessive force or greater than necessary force in physically disarming appellant, which we do not conclude on this record, there is no evidence that appellant reasonably believed that his use of force against the officer was immediately necessary to protect himself. That is, no evidence showed that appellant believed it necessary to grab the weapon to defend himself. Instead, the evidence demonstrated the appellant acted as he did, impeding the officer's efforts to disarm him by grabbing the weapon, the alleged conduct of the charged offense, to protect his gun. The video recording of the encounter depicts appellant grabbing the weapon after Officer Ermis reached to release the clasp on the shoulder strap while simultaneously saying, "Whoa, whoa, whoa, hey, no, don't disarm me, man." Even if the officer's conduct of physically disarming him constituted greater force than necessary, as appellant claims, the record demonstrates that appellant's conduct in interfering with the officer's authority to disarm him was to prevent the officer from taking his gun. As the trial court aptly noted when denying the self-defense instruction, appellant wasn't defending himself. He was defending his right to have his gun. The evidence, viewed in the light most favorable to the requested instruction, reflects that appellant acted in defense of his weapon, not in defense of himself. Because the record does not reflect evidence supporting each of the elements of self-defense, we conclude that appellant was not entitled to a self-defense instruction. A defendant is entitled to an instruction on self-defense if the issue is raised by the evidence, but if the evidence, viewed in the light most favorable to the defendant, does not establish self-defense, the defendant is not entitled to an instruction on the issue. Thus, the trial court did not abuse its discretion in denying the requested instruction. We overrule appellant's third point of error. Conclusion. Having overruled appellant's 3 points of error, we affirm trial court's judgment of conviction. And that's it. Well, anyway, I don't think that was as bad for CJ as it could have been. I think the biggest error that I saw was he didn't brief the one issue of the speech-only defense. The denial of the motion to suppress, I think, was probably reasonably raised because, as the appeals court did note, that he did touch on the issue of he didn't believe that there was reasonable suspicion for detention, and he did touch on that at cross-examination of Officer Ermis. Now, he fails on it, but I can see him. When you're doing an appeal, I can see throwing all your points of error out there at once. So that wasn't that bad. He had one potential winner in the speech only. Well, I don't think he would have won on that because it wasn't speech only. But anyway, it was worth a shot, I guess. I don't want to be too critical of CJ on this. He wasn't even a law student when he did this. But anyway, I hope you found that entertaining. I know you're all wondering about the woodpecker. The woodpecker got away. Andy Oakley was not the fastest gun draw in the West on that one. I just got a shrug on that. Anyway, thanks for watching. Have a great day.